5 seconds to go. Start. Therefore, since the previous criminal history of the applicants denotes that they had been or are being separately charged, tried for those offences before competent courts, there is no question of such offences constituting offence of organized crime. In Prakash vs. State of Maharashtra, a division bench of this court was considering the challenge to the applicability of Makoka. The court observed as under in paragraph 10 of the judgment. For the purpose of organized crime, there has to be a continuing unlawful activity, and there cannot be continuing unlawful activity unless at least two charge sheets are to be found to have been lodged in relation to the offence, punishable with 3 years imprisonment during the period of 10 years. If no illegal activity as contemplated by Makoka are committed after 1999, then the past activities prior to 1999 may not be of any help for registering any FIR only on the basis of those past activities, as has been observed by the division bench of this court in writ petition number 689 of 2005 and other petitions. But if two or more illegal activities are committed after 1999, then the past activities can be taken into consideration in order to show the continuity. We are therefore not in agreement with the submissions made by Mr. Pradhan that on the date of registration of FIR against the petitioners, they had not committed any act as contemplated. While offences committed prior to 24th February 1999 cannot amount to organized crime, since this offence was not on statute book then, even post 24th February 1999, crimes could be tried as organized crime only if information in respect of these crimes is permitted to be registered as organized crime and sanction is accorded for prosecution for such crime under section 23 of Makoka. Such are not the facts in the present cases. There is no substantive crime which is allowed to be registered under Makoka. Offences in crime numbers 37 of 2001 and 38 of 2001, for which approval was sought, are not subject matter of these trials. When crime numbers 3007 of 2001 and 3008 of 2001 were registered, upon receiving approval, there was no crime reported. Seizure of weapons is subsequent to registration of these crimes for which the concerned accused persons have been acquitted. Consequently, without there being a substantive offence indicating continuity, there would be no continuation of the unlawful activity and as a corollary, no continuing unlawful activity. A look at provisions of the punishment, section 3 of the Makoka would fortify this conclusion. Section 1 and 2 of subsection 1 would show that if such offence has resulted in death of any person, the offence of organized crime would attract death sentence or life imprisonment with a fine of rupees 1 lakh. Now, if only old charge sheets should be held as enough, a person acquitted of a murder charge in the past would be liable to be sent for a life term in spite of acquittal simply because a charge sheet had been filed in the past. Had this been contemplated, the learned judge special court would have charged accused number 1 Shiva of offence punishable under section 311 of Makoka and note 1 punishable under section 312 of the Makoka. Since Shiva had been charged once of murders, serial number 9 in the chart, and acquitted, same would hold good about the other gangsters. Advocate Tiwari, the learned counsel for Mahmood and others, relying on judgment of the Supreme Court in Dilip Singh vs. State of Punjab, reported at 1997-3 Current Criminal Journal 233 that charge sheets cannot be made the basis of guilt or innocence of an accused. Therefore, it is clear that the offences referred to in various charge sheets are not such offences and consequently an offence punishable under section 3 of the Makoka has to be different from those for which such accused had been charge sheeted in the past. past criminal activity only aggravates the committed activity amounting to an offence and attracts provisions of Makoka. In view of this, since the appellants are not shown to have indulged in any crime which can be said to be continuation of past criminal activity, provisions of section 3(1) of the Makoka are not attracted. It cannot be said that the appellants have committed the offence of organized crime. It may not be out of place to state at this stage that in Prafulla Supra, the High Court also referred to and relied upon its own decision in the case of Altaf Ismail Sheikh versus State of Maharashtra. More particularly, para 24 therein, which reads thus: the section 23 of the Makoka, which opens with non-obstant clause and further clothed with negative words, clearly discloses the mandate of the legislature that the cognizance of the offences under the Makoka Act should not be in routine course but only upon the facts disclosing the applicability thereof and satisfaction of the officer of the high rank, the minimum being of the rank of Deputy Inspector General of Police. In that regard, stop.